Hello class, this is Ryan Ellis. A brief introduction about myself. I have obtained my bachelor's degree in business administration from Miller Mock College Online. Education is very important to me, and which brought me to my pursuit of my MBA in business administration here at Alberta University. This is my first semester at Alberta University and one of two classes that I am currently enrolled in. I work as an accountant for America's oldest hat manufacturer, and as many of you may know, manufacturing jobs and labor unions oftentimes go hand in hand, which leads me to my presentation on labor unions, and more specifically, the Northwestern University football team and their right to unionize. I will begin by discussing briefly the information in Chapter 17 on federal labor laws and the rights to unionize. So I'll be discussing federal labor laws, union organization, collective bargaining, which is a major part of unions, strikes, lockouts, and unfair labor practices. So to begin, federal labor laws. The first law enacted in 1932 was the Norris-LaGuardia Act, which gave protection to employees for peaceful striking, picketing, and boycotts. This established a national policy that allowed for employees to unionize or to organize. The National Labor Relations Act was established in 1935 and stated that employees had the right to engage in collective bargaining and the ability to strike. This also defined unfair employer labor practices. Some of those unfair labor practices were that the employer cannot interfere with employees trying to form, join, or assist labor organizations. Employers cannot dominate labor organization or their financial contributions and other support to the labor union. Employers cannot discriminate in hiring or awarding tenure to employees based on their union affiliation. Employers cannot discriminate against employees for filing charges or giving testimony against the employer. Refusal of bargaining collectively with the employees' representatives is also considered an unfair employer labor practice. The National Labor Relations Board, or the NLRA, was created, and the purpose of the NLRA is to oversee union elections and to prevent employers from engaging in unfair and illegal union activities and unfair labor practices. If an employee or the union or the employer believes that federal labor laws have been broken, they may file a charge with your regional office of the National Labor Relations Board. The National Labor Relations Board then has the authority to investigate these charges and file complaints against the employer or the employee. The employer may be issued a cease and desist order to stop their unfair labor practices. These orders can be enforced by a federal appellate court if necessary. And to be protected by the National Labor Relations Act, you must be an employee defined in the statute. The Labor Management Relations Act of 1947, which was also known as the Taft-Hartley Act. This defined things such as the closed shop, which a closed shop is requiring union membership as a condition of employment. This also defined a union shop, which does not require union membership as a prerequisite of employment, but often requires union membership after a certain period of time. A union shop is illegal in 23 states that have right-to-work laws, which make it illegal to require union membership for continued employment. The Labor Management Reporting and Disclosure Act was enacted by Congress in 1959. This established an employee bill of rights and reporting requirements for union activities. This oversees union activities such as elections and ensures that union members have rights. This also outlawed the hot cargo agreements, which employers voluntarily agree with unions not to deal with goods produced by non-union employees. So this is discriminating all those people that are not in unions. Next, I will be discussing union organization. The first step to becoming a union is having employees sign an authorization card stating that they are in favor of having a certain union. Employees present these cards to their employer and ask for formal recognition of their union. Employers do not have to recognize the union at this point in time. If employers don't recognize the union, the workers will present their cards to the National Labor Relations Board and ask for an election where at least 30% of workers need to be in support of a union for an election to even be held. The National Labor Relations Board then monitors the election and ensures that there is a secret ballot. If there is majority support for the if there is majority of support, then the National Labor Relations Board certifies the union. At this point in time, employers have to recognize the union. Employers do have the right to limit campaigning activities during working hours and on company property. They do not have to willingly give employees the ability to campaign for a union on their property or during their work time, but it is legal to do it during breaks and after work hours. Employers also have the right to not allow solicitation of any kind in certain areas, which includes campaign solicitation. An example of this is if you work in, say, a department store where you have customers constantly coming in, or in certain areas, you can campaign for your union in specific areas designated by your employers. Now, in a break room or in a back room that there are no customers, or it is not a distraction, then an employer is more apt to allow for campaigning. Employers can also campaign against the union, but the National Labor Relations Board monitors this activity very closely so that the employer does not wield their power and takes advantage of the employees. After this, then somebody is also designated then controller of the union. Next, I will be discussing collective bargaining. And collective bargaining is negotiations between an employee and employer, mainly the union and management. And this negotiates terms and conditions of their employment, which can include wages, benefits, working conditions, and other matters that are deemed important that the employees or the employer feel are important to discuss and bargain on. If collective bargaining is when a union becomes certified, they are able to demand new terms and conditions of employment to be negotiated. So this essentially would create a whole new contract, or they're able to argue for a whole new contract to be created. Collective bargaining does not mean that one side has to win over the other. It's simply two sides of your organization, being management and the workforce or the employees, coming together and negotiating on, again, things that they feel are relevant or important to their terms of employment. And also, collective bargaining, it assures that you are bargaining in good faith and trying to resolve the issues and come to a consensus agreement. Next, I will begin discussing strikes. Strikes are when collective bargaining breaks down, unions can vote to strike. To strike means that you leave your job in an attempt to get management to agree to your terms and conditions of a contract. Oftentimes, striking results in pickets where you walk around with signs stating your complaints. Employers are allowed to hire replacement workers in times of strikes. There are also times where striking is illegal. Violent strikes or threat of violence are illegal. You cannot deny management or replacement workers from entering and working. Sit-down strikes are also illegal. Sit-down strikes are where you sit at your job but you refuse to work. There's also a wildcat strike where a minority of members of a union call for their own strike because they don't agree with unions. This is a form of an illegal strike. The right of strikers after a strike ends. The company has the right to hire permanent replacement workers. If the replacement workers are suitable and they seem to be working well for the company does not have to bring back the striking workers. This is a risk that striking workers voluntarily take on. If the company has not hired replacement workers, then they are required to take back the striking union or the striking workforce. Employers may not discriminate against the workers for striking. It is their right to strike. Again, they have the ability to hire replacement workers, be it either temporary or permanent replacement workers, and ultimately they can decide whether to bring these employees back, but they cannot discriminate against them for striking. Next, I will talk about the company's counter to striking, which is lockouts. A lockout is an employee or employer's version of a strike, and the purpose of a strike is that you simply lock out your employees before they vote to strike themselves. A big reason for this is if you feel that your employees or the union that your employees are in or about to strike, or if they're holding out for, say, your busy season, before it gets to that point where they have more weight in their argument, you can lock out your employees. And lockouts cannot be used as a union breaking tool, though. You can't use a lockout to force employees to break their union. And the employer must show some form of economic justification for instituting a lockout. Next, I will be discussing unfair labor practices. And I will be discussing this in two forms: by unfair labor practices by the employer. And these are things such as the refusal to recognize a union or the refusal to bargain in good faith. If the employer interferes with, restrains, or coerces their employees to form a union and bargain collectively. Also, an employer cannot dominate a union. They cannot discriminate against union workers, and they cannot punish employees for their involvement in a union. Unfair labor practices by the union would be a refusal to bargain in good faith, to picket, to coerce unionization without majority support, demand the hiring of unnecessary workers, discriminate against non-union workers, agree to participate in a secondary boycott, which is boycotting your company's vendors or their customers, engaging in one of the illegal strikes that I previously talked about, or charging excessive membership fees. So all of this is leading to the article that I read on the University of Northwestern's football team and their right to unionize. The thesis of the paper is that, I'll go through my thesis here, that the Northwestern University football team did win the right to unionize by the National Labor Relations Board. The argument for unionization is that they are employees, that they do work about 50 hours per week on average, and that's during the season. During their off season, they were arguing that they still put in about 20 hours of what they consider work during their off season. So again, the main point to this article is, what are they? Are they considered students, or are they considered employees? The argument for the university against unionization is that they are simply students and they're not employees. Again, the athlete's argument is that they are an athlete first, that they are there to simply play their sport and get an education on the side. Again, the adverse side of this is that, or the university's aspect of this, is that they're a student first and they get to enjoy something that, or they get to do something that they love by enjoying playing their sport of choice. One of the main arguments, again, that the students have, or that these athletes have, is that they are struggling with their basic needs, and their basic needs being that medical care, medical coverage is a very important and very hot topic with this labor unionization, and I'll get into that in more detail shortly. And also, students want a voice. They want to have the ability to collectively bargain at a table with the university and with college football in general. So these are the main points of the article that I will be discussing. I'll get into my critical analysis. So again, one of the main arguments is what are they? Are they an employee or are they a student? The main argument for these athletes is that they are required to dedicate about 50 hours per week during the in-season of their sport to their sport. And in the case of the article that I read, the sport being football. Again, they can be punished, if they don't dedicate their time to sport. They have to train, they have to practice, they have to study film. All sorts of things go into being an athlete. On top of that, then they have to worry about their school, their schooling, and their being able to attend class and study and prepare. And they can be punished in terms of they could lose playing time, they could lose their scholarship if they do not meet requirements in terms of meeting, team meetings, if they're missing games, if they're missing practices, they could ultimately lose their scholarship, which is what brought them to the university to play football, or again to play their sport, but in this case it's football. These football players, they see playing football as a job. Again, first and foremost, they see themselves as an athlete and a football player first. They don't see themselves as a student because, again, they have to dedicate their time to their sport. In a survey done between major college sports being football, basketball, and baseball, athletes said that they average about 40 hours per week dedicating their time and energy to their sport. Supposedly, there's supposed to be a 20-hour rule instituted by the NCAA, which states that coaches can't take up more than 20 hours of their athletes' time in a given week. But according to one source, being the Big 12 Commissioner Bob Bowlesby, this rule is a complete joke, and that paperwork is constantly falsified, meaning that, they have this 20-hour rule, but nobody's following it, and that these coaches are demanding more than 20 hours per week out of their student athletes. Also, in a poll, about 15% of men's football, baseball, and basketball players said that they would have had chosen a different major if they had not been athletes, meaning that they simply do not have time to go in their field of choice because they can't dedicate enough of their time to their field of study. A big example of this, and one of the main supporters of the football team unionizing, which was quarterback Kane Coulter, who has since graduated and is actually on his way to attempt to become drafted into the NFL. He said that he had to drop his pre-med major classes because he simply did not have enough time to dedicate to classes and play football. If he didn't focus on football, he could have potentially lost his athletic scholarship, which again is very important to him because now he would have to pay for an education on top of trying to play football, or now he's going to rack up what most of us do, is student loans and debt. These athletes, they receive scholarships based on their athletic prowess, so ultimately that's what's important to the university. They want to get the most out of these athletes in terms of their athletic prowess. They want the best for them in terms of winning football games and bringing fans and money to their university. So that's what's important when they're giving out these scholarships. It's really not education based. They're not giving out an athletic scholarship for somebody to come get a doctorate degree and be some successful surgeon. They're giving out these athletic scholarships for these football players or basketball players or baseball players to give their all to their team and ultimately win games and bring fans and ultimately drive in money. So again, this leads to the question, do they have the right to unionize? According to the National Labor Relations Board in Chicago, they do. Another question is, will they be protected under the federal labor laws, which again now, since they are being deemed employees and that they have formed a union, they should ultimately be protected under the federal labor laws, which we have discussed, which I went over in my chapter analysis. And again, they have formed a union. Again, one of their major issues is collective bargaining. They simply want a voice. They want to be able to discuss issues that they run into on a daily basis every season, every year. One of the main issues and one of their biggest focal points on becoming a union is medical coverage for injuries suffered while playing and for after they are done playing. A major example of this is a former player, Jeff Yarbrough, broke both of his legs while playing football, and now he can't get the metal rods that were placed in his legs taken out because he simply can't afford it. And it isn't covered by the university. The university feels that they gave him a free education, that they are not required to pay his medical bills related to anything with this injury. They feel that, well, the athletes feel, and what one of their main points in arguing is that they feel that any injury suffered while playing should be covered during their time on the team and after they graduate. They're not asking for free health care, but they feel that any injury suffered while playing, and that's a direct result of their sport, should be covered, and it should be covered for a lifetime. One of the major concerns for the NCAA and Northwestern University, specifically in this case, is that through unionization, this will force a pay-for-play rule, where these college athletes are then going to get paid to play their sport. And with this, smaller universities such as Northwestern University, which is, even though it's a Division I school in terms of football, they still consider themselves a smaller school, and they're more on the education, or one of their prowesses is education. And their fear is that they will simply not be able to compete if there's a pay-for-play. If these unions ultimately lead to these athletes being paid to play their sport, they will not be able to compete with your major market universities such as a Texas or an Alabama that has a huge fan base, that they have huge stadiums that make tons of money for the university, that have an unlimited supply of money to essentially throw at these top athletes. It's going to create a centralized power in terms of these major universities for their athletic programs, and it's going to leave teams like Northwestern and other smaller universities just hung out to dry, which then their argument is that if this happens and that student or that athletes are eventually paid to play, that they're going to focus solely on education and may drop out of Division I altogether. Again, with this, they're saying that these athletes will choose a school that can pay them the most money and give them the best chance to make it to the pros, and education is going to become very minimal in their terms of choosing a university. Also, another major concern by these universities are that if they are able to unionize, this is ultimately going to lead to labor strikes and lockouts, which would be unprecedented in the collegiate level, and would create a whole new set of issues. Again, now you have students, and you have to define, well, if they're students, yet they're employees, if they're striking against their sport, are they allowed to attend classes? And you have to be able to differentiate somewhere, and ultimately, I mean, it's going to lead to legal battles and other such forms, and it's just going to create a whole new set of issues that I think, at least in terms of the universities, don't even have to worry about. Another important part to this analysis is that scholarships, if these athletes become or would be considered employees, that scholarships then would become or would be considered taxable income. With that, this is going to create a whole new set of, or this lead to a whole new discussion and analysis in terms of labor laws and tax laws. And this is something I'm not really going to dive into, but it is something that I did want to bring up as a food for thought, that if these athletes become employees, scholarships would then be considered income because they're getting paid to play, or essentially that the money that they are receiving in a scholarship, their free education, would then be considered income, even though it's not directly going into their pocket that allows them to purchase, a new car, a new home. It's still considered an income. So my reaction to the thesis, my initial reaction is I do see both sides of the argument. The students want a voice at the bargaining table, which I do feel is very important, and they should be able to have a right to negotiate what they feel is fair. I feel that there has to be a limit, though, that the whole pay for play should just be thrown out and not even be considered. What I do think is important, what's something that can be reached without having to form a union, is the healthcare aspect. I do feel strongly that as an athlete, if you do get hurt while playing your sport, the university should cover you, because again, you're giving your body for the sport and for the university. I mean, you're laying your life and essentially your body on the line every Saturday that you go out and you play a game of college football against an opponent. If you get hit wrong and you break your leg or tear an ACL, that's something that just doesn't heal overnight, and they are expensive medical expenses. You're having major surgery, something that I feel should be covered by the university, because you're doing this as a help to them. You're helping them make money by winning games, and you're creating popularity for your school. If you get hurt while playing, these kinds of medical costs should then be covered by the university. Again, the university feels that giving these student athletes a free education, at least those that have received scholarships, is payment enough. And again, I do see this point, and I think this is ultimately the very important point for the university, that most of these universities' tuition to attend is $30,000, $40,000, $50,000 a year, that these athletes essentially aren't paying for because they received what is considered a full ride or an athletic scholarship to attend this university. Wouldn't that be considered payment enough? These students aren't racking up mounds of debt that they're ultimately going to have to pay after their education is over with. Also, on top of that, they're getting free room and board, they're getting free meals. They have the time now that they don't have to get a part-time job or even a full-time job to support themselves while on campus, or while playing their sport and attending class, because now that they don't have to worry about paying for their education. They don't have to worry about paying for their meals. They have 3 meals a day at the university's cafe or their lunchroom. Also, they have a free place to stay being in the dorm that they don't have to pay for. On top of that, they have now the time to dedicate to their sport because of these athletic scholarships. I do believe, again, just wanted to touch base on this one final time, that the major issue that can be resolved, again, without the need for a union, is the whole healthcare aspect. I feel that this is something that I think this case with Northwestern University is good because it brings attention to what ultimately they feel is most important, being healthcare. And I feel that this is something that the student athletes should have a voice on and be able to express how they feel and what they feel are their needs, being health coverage for now in the season and for a lifetime on sports related injuries. And again, I feel it's important, and the fact that if it takes this national attention of Northwestern University unionizing to bring this to the forefront and to get this negotiated, I applaud Northwestern University, but ultimately I would have to side with the university, that I think unionization is going to lead to a whole mess of problems, and ones that aren't going to be beneficial to the students or the university itself. Thank you.